brought by the ICE deputy Kate Mills from the Office of Congressional Affairs. She says that after a review of 23,259 detained individuals, less than 1%, that's less than 1%, are identified as provisionally amenable to exercise of prosecutorial discretion. And this is pending a result of a background check. So this is a study that shows that only, of the detained people, only 1% would actually, according to an ICE official, according to ICE data, that would be amenable to this program. And then the second point to consider from our communities is that, for example, in the situation with Ms. Wong, as Kate had mentioned, for a father of 4 undocumented children who works 60 hours a week, and we deal with these cases every day, who gets stopped at a random checkpoint asking for driver's licenses, which are an obvious effort to an assault against immigrant communities by asking them for a driver's license on the way from work. That individual is arrested and has no pathway and has no prosecutorial discretion or favorable exercise of prosecutorial discretion does not apply to that individual, even though that person does not have a criminal record. And we know from statistics that 45% of the over 1 million deportations have not had a criminal record. So part of the reason why, I have a question that's going to follow this. Part of the reason why we have these issues is because of federal policies, and the only person I mentioned was Kate, that secure communities in 287G, which is a community program that deputizes local law enforcement, and secure communities, which is a database which allows local law enforcement to identify who an undocumented immigrant is or who an immigrant is, have led to mass detention and deportation. So my question is, considering these failures that prosecutorial discretion and administration have had on our communities and addressing immigration issues, what steps has ICE and DHS made to stop mass detention, to stop mass arrests that have led to these types of programs which you're trying to implement, which are not actually resolving the issue?
Well, thank you for your question. I know that you're very passionate about this, and I want to thank the speaker for sharing her story. Just some background. With the case review that Kate mentioned, of the 300,000, of those 12,000, so to speak, that are in detention setting, I think I mentioned in my remarks, actually, we've done a pretty good job based upon our risk assessment and how we put people in detention, screening people to go in detention, that if they shouldn't be in detention, they are not put in detention. In fact, we have over 25,000 persons now on alternative detention, more on bond, audited orders for cognizance or supervision. And so the reason this number is small is actually, for us, a good thing to show that our policies are actually working. We believe that if we found a lot of people that merited prosecutorial discretion in our detention facilities, that had meant that the previous policies that we had been putting out for the last 2 years were not working. And so that is why we actually believe the number is not all that startling. And so that's just some feedback on that number. In terms of the issue of local policing exercising immigration authority, this has much concern for us as well, myself as the public advocate. I understand that there are a lot of times communities that might have been seen as being racially profiling or might not be violating civil rights issues. What you have to know with secure communities, and you did a very good explanation of it, which is a biometrical sharing of data, and 287G, which allows for persons in the jails to work with ICE, the jail administrators, the officers, and the police to share information data back and forth. Nothing can happen with ICE until ICE decides it happens. So prosecutorial discretion is happening at that level. Let me explain how. So if there is a data hit, and person is, it's undocumented, but they're here because they entered without inspection. It's a pure civil issue. There's no criminal issues. When that information goes back to the field office, they will not issue a detainer on that individual because they do not meet our priorities. In fact, of the 11,000 detainers issued in the state of Georgia, 9,000 have had some kind of criminal context. The rest have been, and I'm going to talk to you about why that 45% you talk about the deportations, why they're not criminal. Remember, ICE has to carry out its enforcement priorities that include people who are entering the border that are recently entering, haven't established equities. That's a priority for the administration. In addition, those that have gotten final orders of removal and they are therefore by fugitives, that's also a priority. So that population of the 45% makes up a lot of that. There's no question and no doubt that we need to do better on our priorities. This is a complex system. There's no doubt that we need to reform the detention facilities. We need to not rely on county jails. Detention, if you have to be in detention, should not be punitive. It does not mean to be punitive. You're not being punished because you evaded the immigration system. You're only there in order for you to comply with immigration proceedings and your court orders. And so actually detention is going down. We're actually of the 33,400 that are meant by Congress to be kept in detention, we're not at that threshold on the daily population. The average length of stay in detention is 27 days nationwide. More frequently, more than half are frequently getting through detention within 2 weeks. And so what we make sure is that detention mirrors what it's supposed to be. Only a mechanism by which you can ensure you can go through removals. The statistic is if you're put in detention, 10% of people will only leave detention who get relief. 90%, because of the complex system of the laws and the inability for relief to be had, 90% will go through removal proceedings and actually go to removal. And so regardless of how long you're there, we should have facilities that have family visitation, that have the ability for pastors and clergymen to get there. We should have contact visitation. We should have internet access. And that's why we just opened the new civil detention facility in Karnes, Texas. More work has to be done, no question. But I do want to make sure that your voice is heard. That's why I am here. That's why I have my community relations officers. And there's I'm checking into that case right now in New Jersey, and there's no reason why we can't have a dialogue if you had a voice in D.C., and that's me.
Can I ask a quick question?
Sure.
In an effort to be proactive, can we have your contact information, your direct contact information? Because we get calls all the time of people being detained in Central County Jail, and they sit there, and the families are freaking out, and there's an ICE hold, a 48-hour detainer ICE hold on them. And part of the problem is ICE often picks them up, and then they are subsequently put in deportation proceedings, regardless of whether or not prosecutorial discretion is exercised. And so my question is, if we have someone in Georgia who's detained, can we call you, explain to you, because all of us have memorized John Morton's memo, can we explain to you that this person needs prosecutorial discretion, and then contact you and have that person hopefully released?
Sure, and you're not able to, ICE.gov on Monday will be updated with contact information for 24 public field liaison surrogates. And so you can, there's a guy named Bill McCafferty in Georgia who will be my field liaison. You can contact him. In addition, they'll have contact information for my office, and you'll leave here today with my business card. So that's